Good afternoon, everybody, and thanks for joining us for another webinar in Conn 2018 webinar series. I'm so pleased to see so many familiar names and folks dialed in to join us today. We put a lot of work into this webinar series, and I'm so glad to see so many friends and clients and future clients find this at least moderately interesting and continue to come back for what I think is a pretty nerdy level of OSHA discussion at this point. And today, no exception, is a subject that I find to be fascinating, and I know that people who have experienced this in their dealings with OSHA find it to be incredibly frustrating. But this is a down-in-the-weeds topic, and I'm glad that so many people are willing to nerd out with me a little bit and talk about this. So today, our webinar topic is OSHA's policy of public shaming, the status of the various programs and policies that OSHA implements with the express or unintended consequence of shaming employers into compliance, and the future of those policies as we settle into almost midway through the Trump administration. I'll introduce myself and have my colleague introduce himself in just a moment. The first faceless voice that you're hearing today is Conn. I'm the chair of the National OSHA practice at Conn one of the founding partners of the firm. My practice for the last 19 years has focused essentially exclusively on representing employers in their dealings with OSHA and the state OSHA programs. I dabble a little bit in some of the other alphabet soup of agencies that cross into the OSHA universe, but by and large, it's safety and health, regulatory, compliance, and litigation issues. Working with my clients to manage investigations, inspections, and enforcement actions, and the full range of litigation with OSHA, including, unfortunately, more and more these days, investigations and potential prosecutions of OSHA Act violations. I'm very pleased to be joined. I think this is the second webinar, or maybe the third webinar now I've done with my newest OSHA partner, Gelb. I'll have Aaron introduce himself, and then we'll dig right into the topic.
Thanks, Eric. Like Eric, I manage a full range of OSHA matters, from compliance audits and inspections to litigating against our friends in the solicitor's office, handling matters both in the federal jurisdiction as well as a number of state plan states across the country. And in addition to the OSHA work, I also do a fair amount of work on the EEO, harassment, and discrimination side. Been in Chicago for about 20 years now, practicing law exclusively on the management side, and joined the firm back in January, so we're coming up on, I think, 9 months now, or 8 months.
And the lights are still on, so if anybody is out there participating today in the Midwest, in striking distance of Chicago, we've got a great in-person program coming up there next month. What is it, Aaron? September 25th?
September 25th. We'll have we'll have a panel talking about OSHA issues with Chicago North Area Director Angie Loftus, Nick Walters, the past Region 5 Administrator, and then we'll have a number of breakout sessions, or an OSHA breakout session covering a number of different topics as well.
And more important than any of that, after that program is over, we're having a launch party to celebrate the launch of our Chicago office. So hopefully folks can get out there and join us. It's going to be a great event. But today, focusing on the matter at hand after that plug, is to talk about public shaming. And the most obvious thing whenever anybody talks about OSHA's program of regulation by shaming or policies of public shaming, they think about OSHA's enforcement press releases. And we're going to talk a lot about that. But that's not the only thing we're going to talk about today. There will be a heavy dose of, what is OSHA doing? What about the state plans? How have those policies shifted and changed over time, over different administrations? And then we'll talk about the legality of that program. I happen to think the way that OSHA has been implementing it the last decade or so is not lawful, and we'll talk about why that is. But then we're going to get into the other things that OSHA does, other programs that OSHA implements, that have a similar effect of public shaming, including OSHA's Severe Violator Enforcement Program, the new controversial electronic record-keeping rule, and then finally the way that OSHA publishes data about fatalities on its website and otherwise. So starting off with the real meat and potatoes of OSHA's program or policies of regulation by shaming, the enforcement press release. And every time I talk about and every time I complain about enforcement press releases on Twitter or LinkedIn or anything like that, Jordan Barab, who's my Twitter nemesis, chimes in to say, hey, you know, the Obama administration didn't invent the enforcement press release. I don't know what you're complaining so much about. And he's right. The Obama administration did not invent the enforcement press release. It's been out there for decades, and it's been utilized by both Republican and Democratic administrations. They've issued enforcement press releases announcing notable enforcement actions. And one of the most problematic elements, I think, about the press release program is also not something that was unique to the Obama administration, and that is the timing of the press release. These enforcement press releases, as long as I've been practicing in this field, have been issued essentially the same day as the citations. Sometimes it's the next day. Sometimes if the citation is issued on a Friday, which is a bad news day, OSHA will wait and issue it on Monday. Sometimes they'll wait to confirm that the citations have been delivered, but it's usually either the day of or within 3 or 4 days of the citations being issued. And we'll talk about this when I talk about the legality of the enforcement press release program. But the concept is the citations are issuing just when OSHA citations are nothing more than an allegation. And I think that's problematic, and we'll talk about that some more in detail. The other very problematic element of the enforcement press release program, which is also not unique to any particular administration, is that the press releases live on regardless of the outcome of the citations. And I don't know how many of you on this call have ever received a citation from OSHA, but if you have, your likely experience has been that the final outcome was different than what was alleged. Maybe a citation item or two or all of them were withdrawn. Maybe the penalty was cut by 20, 30% or more. Characterizations, maybe they allege that you committed a serious violation and it ended up as a final order being an other than serious violation. Well, those things, those ways that the citation change are not ever reflected on OSHA's press release page or anywhere that these press releases live online. So if OSHA were to issue a press release and say, you know, company XYZ is a bad actor, we just cited them for 11 willful violations and issued a proposed penalty of, you know, $1 million, and we dumped them into the nasty Severe Violator Enforcement Program, and, you know, that's the end of that press release. A year later, after some, you know, demonstration, after the employer, the accused, has their day in court or is just able to share additional information with OSHA through an informal settlement conference or formal settlement discussions, and OSHA realizes, gosh, you know what, we got it wrong. We totally missed the boat on this one. They withdraw items. They say, you know what, you've demonstrated to us, employer, that you're not a willful violator, so we're going to change that characterization or just outright withdraw the violations. Well, that's great. You got some relief. Your penalty is lower, and you can, you know, hold your settlement agreement and wave it around and say, look, we're not the bad actor we were accused of. But that press release lives. It's still on OSHA's website. They still have press releases on there from, you know, more than a decade ago that say nasty things about employers that have later proved to be wrong. And there's no effort by OSHA to change that or correct that or apologize for that or anything. And here's the correcting the record discussion. I had, you know, a personal experience with this. You know, I'm sure every OSHA defense lawyer does. The one that offended me the most was a really nasty press release that was issued about a hospital system that I represented. They were issued one of these general duty clause violations related to workplace violence. And if anybody on this webinar today is in the healthcare space, you know that is a, you know, that's an issue that, you know, folks in the healthcare system, the healthcare universe have to deal with. My client, no exception, was dealing with it. They had, you know, one of the largest public mental health care facilities in the country, and they had a very, very sophisticated workplace violence prevention program, but you're never going to get to zero incidents. And here, OSHA walked in on a employee complaint that was union motivated because a big bargaining was coming due soon, and the hospital was about to be sold, and the union was trying to secure its place and secure its role through that transaction, and as the bargaining was coming up, very complicated situation. But at the end of the day, with the union sort of egging OSHA on, they came in and issued one of these violations and said there were some incidents of workplace violence, and so we can conclude that the facility's workplace violence program is ineffective and should be improved immediately to protect employers and ensure a safe workplace. That was a quotation from, I think it was from the Assistant Secretary of Labor for OSHA or the regional administrator in that region, if I recall correctly. That press release really did a lot of damage to the employer, really impacted the transaction that was going on at the time, and really cost my client caused my client significant harm in the public space because of this allegation, this really nasty press release that was issued. Lo and behold, after a few months of litigation, discovery, where we demonstrated that we did have an effective workplace violence prevention program, that our data, objectively, we were one of the best performing mental health care hospitals in the country on a per bed, incident basis. And then, in fact, our program met all of the recommendations of best practices out there, both by OSHA and by industry guidance documents. And OSHA had no choice at that point to completely withdraw the citation. They had absolutely zero chance of winning that issue in litigation. And they withdrew it, and on OSHA's website you can see, if you know how to dig around for enforcement data, that the violation that was originally alleged was withdrawn. But this morning I went on to OSHA's website and found that ugly press release that's still sitting up there, snapped this picture of it and dropped it into the slide. So it shows that even when OSHA is dead wrong, and this is not just a horse trading and a settlement, well, sure, we gave you a penalty discount, but OSHA still believes you were wrong. Here they outright withdrew the citation, nothing left, and still we have this ugly press release out there. I'm sure Aaron has a similar experience, and probably most of you on this call, well, hopefully most of you don't have this experience, but you know that this sort of thing does happen. Aaron, what's your story like this one?
Yeah, we had one where the area director issued a pretty nasty statement that said something to the effect of, this was an employer that received 3 repeat citations for violating the lockout standard. So the statement was something to the effect of, these repeat citations demonstrate that this is an employer that doesn't care about safety or its employees. And what always stuck in my craw about that one was this was an employer that had essentially restarted industry in a struggling town. They had built a daycare center for their employees on the premises of the facility, so people could more easily work. They were certainly trying their best. Did they fall short? Perhaps, but somewhat like your situation, 2 of the repeats were withdrawn. The penalty was reduced significantly, and just like you said, that press release is still up on the website. And what made it worse was it was picked up by someone, and they don't know whom, and placed on their Wikipedia page. It's still on their Wikipedia page. They still get asked about it by customers, by vendors, and the like. So it's something, and that's, I think, at least 5-6 years old, that is still impacting their business.
Yeah, and that's something that we've been trying for years to fix with OSHA. Is there's 2 ways to fix this. One is you don't issue the press release until the citations become a final order, so that you don't run into the situation where you've got the falsely accused getting just lambasted in the public space because of your press release, or you correct your press releases, take them down, fix them, issue an apology, issue a retraction, amend them, something that shows that hey, we at OSHA, we got it wrong, and we should not have tarnished the good reputation of this employer. So far, OSHA has not taken either of those suggestions from me and run with them. It's probably going to take a lawsuit one day challenging the press release policy or challenging an individual press release. And we'll talk about how that might be done I'll also talk about why that hasn't been done yet as well. But first, let me just satisfy Jordan Barab's concern that I might just be painting this as an Obama-era problem, and talk about how this policy has spanned multiple different administrations. So going back to the Bush administration, which is sort of an establishment Republican administration, that sort of ran things to the right of the Obama administration, but not necessarily in a radical way. The Bush administration did issue enforcement press releases. Their policy, as a general rule, was that they reserved the enforcement press releases for the most significant enforcement actions. And typically it was matters where the cumulative penalty amount of the proposed penalty, not the final penalty, but the proposed penalty, was at least $70,000 or a matter that involved multiple fatalities. So in those, very significant enforcement actions, and if you practice in other areas of law, if you've got environmental under your belt, you might not consider a $70,000+ enforcement action to be significant, but in the OSHA universe it is. Certainly it was back during the Bush administration. So as a result of that threshold, a $70,000 total penalty, we saw about 150 enforcement press releases a year. A little more than 10 a month, certainly not on average, one a day. We'll talk about what the Obama administration did with this policy. But, during the Bush administration, we saw almost 900 press releases over the final 6 years. And I use the final 6 years for the Bush administration and the Obama administration because that allowed them time to get in, get, political appointees in place, and implement their own policies. So at this point, you're looking at, whatever the Bush administration intended to do from an enforcement press release standpoint, you're seeing it right there. So the about 150 press releases per year. That's just on a pure count basis. What about the tone? The tone of the enforcement press releases during the Bush administration, and really kind of all Bush administration and backwards, including Democratic administrations, were very black and white, very neutral. They sort of stated the facts of the enforcement action and left it at that. And that's why I think the policy was by and large being lawfully implemented at the time, because it wasn't really about shaming. If you look at these press releases, and here's an example. This was one where I'm pretty sure this was an explosion case with serious harm to employees, probably even a fatality case. Looking back at it, 10,000 pounds of flammable liquids, multiple employers involved, over 20 violations were issued, very, very serious matter. And you look at it, there's no quotation marks anywhere in there. So there's no nasty quote from an employer like Aaron and I just talked about. The examples we gave were both during the Obama administration era. Here during the Bush administration, there's no quotation from anyone at OSHA bad-mouthing the employer, and it's basically just a recitation of the situation. The event happened. The company was issued 13 serious citations with $18,000 in proposed fines, and the companies have 15 days to contest the citations. Pretty neutral. It doesn't seem to be intending to embarrass anyone. It doesn't seem to be intending to shame anyone. It does have more of an educational quality. Hey, folks in industry, be aware that these sort of accidents can happen, and when they do, these kind of citations can issue. It is really more about educating industry and, setting an example, so to speak, but not about shaming an individual employer. Things changed pretty dramatically during the Obama administration, both in terms of frequency and in terms of tone. And this quote right here, whenever I talk about OSHA's policy of regulation by shaming, everyone thinks that that's my jaded defense lawyer's term for something that OSHA's doing. In fact, this is OSHA's own language. This is David Michaels, and I had never heard it referred to as regulation by shaming because, frankly, they weren't using it in that same manner in the prior administration. But David Michaels, the longtime OSHA administrator during the Obama administration. This is his quote talking about enforcement press releases. In some cases, regulation by shaming will be the most effective way for OSHA to encourage elimination of serious hazards. We at OSHA will not hesitate to publicize the names of violators, especially when their actions place safety and health of their workers in danger. To do this, OSHA is going to issue more hard-hitting press releases that explain more clearly why we cited a specific employer. I had a conversation at a dinner party with David Michaels shortly into his tenure as the head of OSHA, after he gave this speech and after they really started ramping up the use of the press releases. There was a particularly egregious press release that had a quote from him, and sometimes OSHA will use quotes from, the area director, the regional administrator, David Michaels, or sometimes even the Secretary of Labor. It's the very, very serious cases where you see the assistant secretary and the secretary quoted in the press release. But there was one that was issued either the day of or the day before. I was sitting with him, and it had this really, really ugly quote from him personally. And I was chatting with him about it, and I said, you probably are not even aware of this. I assume there's somebody in a back room whose job it is to write these quotes for press releases, and you don't even know about it. He said, no. Whenever you see a quote from me, that quote is really from me. This program is really important to me because since I've been the assistant secretary for OSHA, the one thing that employers have complained to me the most about are these press releases. So I know they're working. So that was in his mind like, hey, if the employers hate it, this is a good thing. We need to do more of it. And they got out there and they did that in a very significant way. So the first thing that they did during the Obama administration was to lower the threshold penalty for what they would characterize as a significant enough enforcement action to warrant a press release. And it had been $70,000 or so during the Bush administration. They lowered that, almost cut it in half. They said $40,000, but man, there were an awful lot of press releases that were issued in the $30,000 to $40,000 range as well, in my experience. So I always say they said the policy was $40,000. In my mind, the policy was $30,000, which, unlike that $70,000 level, a $35,000 OSHA enforcement action is pretty ubiquitous. It's a small handful of serious violations can get you there. It doesn't take willful and repeat violations. It doesn't take, a major, 4-month-long intensive OSHA inspection to put together a citation package that triggers this duty. And as a result, rather than about 850, 870 press releases issued in the last 6 years of the Bush administration, in the last 6 years of the Obama administration, we saw almost 2,000 more total press releases than during the Bush administration. The per year instance or frequency of the press releases jumped up from about 140 a year to over 460. So more than one a day, including the weekends. And so really OSHA was not issuing these press releases on Fridays because that was a bad news day, and they didn't want it to get lost. The whole point of this was to get as much publicity and as much traction as possible. So between Mondays and Thursdays, they were issuing multiple nasty gram press releases every day. And it wasn't just the frequency that went up. It was the tone and the quality and the nature of the press release. One thing that they did was they started writing them like they were these Harlequin novels. It was tugging at your emotions and trying to present like these, and they were. I mean, the circumstances, I don't want to, belittle the scenario, right? They would be writing about something that was probably tragic or at least very significant, but they were writing about it in a way that was intended to, elicit an emotional reaction from the reader, and it was emotion for the injured worker and probably hatred for the employer, and that was the spirit that I think these press releases were written in. And here's one example we found where they talked about sort of the story about this person who went to work. It was early in this person's career. or making final plans for her wedding and looking forward to a new life with her future husband, and then this tragic thing happened at work. I mean, there was certainly nothing like that in the decades preceding it in the press releases that OSHA issued. And it was, with the intent of making you feel, great sympathy for the person who was harmed, and of course we all do, but also making you feel great sort of anger towards the employer. And again, these press releases are issued the day of the event, the day that the citation is issued, before the employer has been able to demonstrate that, hey, this was not something we had any control over. Maybe it was a defect in a product that was provided by a third party. Maybe it was employee misconduct. And, of course, in OSHA's mind, it's never the employee's fault, but, sometimes it is. And before the employer has had an opportunity to defend themselves, they're being cast as the villain in this novella that OSHA is writing about them. And it's, and it had the exact effect that OSHA was going for. And that's why people were complaining to Dr. Michaels and why he responded that it was obviously, working. And that was their view of it. In addition to this sort of appeal to the emotion, the other thing that OSHA started to do during the Obama era that was relatively new, it happened very, very sparingly in prior years. Now it became 100% automatic. If there was an enforcement press release, it included a quotation from a senior OSHA or Department of Labor official. And these quotations were ugly. I mean, it was, in addition to telling this emotional story, it was very much, blame, clear blame, and not just about the regulatory violation, but about the cause of an injury. I mean, they would say things like, the no excuse for taking chances with people's lives. This employer ignored or severely delayed fixing known hazards. This was a press release in another instance where OSHA issued many, many willful violations that were all wiped out. So, in fact, OSHA's violations and allegations were wrong, but such an ugly statement to make about the employer in a circumstance where they were proven wrong. These repeat violations demonstrated a lack of commitment to employee safety, when in fact, and I think this might even be the example that Aaron was talking about, where those citations did not remain as repeat violations, and at least 2/3 of that package was wiped out completely. And this was a company that absolutely did care about its employees, and we know that from our personal relationship with them, but an ugly statement to go out in the press that continues to haunt that employer. Here's one that says, to reduce its own costs and meeting production targets, this supplier cut corners on safety at the expense of workers' lives and limbs. Another one, this was a quote that you actually saw at least once a week in the press releases that OSHA put out. No worker should have to risk his or her life for a paycheck. Well, of course, that's a true statement, but the suggestion, obviously, is that this employer made its employees risk his or her life for a paycheck, and rarely is that proven true. And again, these things are issued at the time the citations are issued. So really ugly, embarrassing, inflammatory, inciting language was, to me, the hallmark of OSHA's press release policy, and why it changed from a press release policy to regulation by shaming. I mean, Michaels was right to characterize it that way. Their intent was, we are going to scare the hell out of all of your neighbors and you and anybody else in that industry, and because nobody wants to have this said about their company. So, we're going to regulate by, negative press rather than regulate by regulation. And so, that was what we saw during the Obama administration. And then a new president was sworn in. And this was
Eric,
President Trump.
I was just going to add, I think one thing that kind of adds a little context to this broad brush that the agency was painting with were the remarks, and I think you were present at the meeting as well, when Patricia Smith, the past Solicitor of Labor, made a comment about retaliation being a standard business practice for American industry. And I think that mindset permeated the Department of Labor and OSHA, and it just led to this belief, so these examples that you read through, where the agency just assumed that all employers, so whether this was an employer like the ones that we've talked about that truly did care and was trying, versus the employers that were willfully, the folks that might send folks into a building to remove asbestos without respirators, the folks that really know that they're skirting the obligations. There was no line drawn between those types of employers in the past administration, as I saw it.
Yeah. Oh, yeah, for sure. I mean, it's the all employers are evil mindset of the agency in that period, and that was reflected right in the tone of these press releases. That certainly no one ever got the benefit of the doubt. And then again, as we talked about before, even when they proved beyond a doubt through defending themselves that OSHA got it wrong about them, these things stayed out there, and it was. I don't want to say it was okay. I think it's wrong to have this stuff live on when it's proven wrong. But when the press release itself was fairly neutral and very black and white and really just for educational purposes, it's not going to hurt you if somebody does a Google search and finds out that you received citations and that you had a right to contest them, and you've got and maybe you can demonstrate that OSHA got it wrong. But when these sort of things are said about you, even if the citations are withdrawn, and this is found in a Google search with your company name, it's hard to come back from that, right? I mean, even if you show, hey, OSHA got it wrong, they had to withdraw the citation. Yeah, but man, OSHA just said, this is the regulator, the expert in the field. They just said that you cut corners on safety at the expense of workers' lives and limbs. They can't be that far off, and they haven't taken it down. They didn't correct it. I mean, it's a bad scene out there, and a lot of employers have suffered pretty negative impact because of these press releases, and still are years later. So then we had a new kind of president sworn in January 2017, and I'm sure unless you're under a rock, you've heard a lot of talk about the different style and the different tone of this president. During the campaign, he campaigned very aggressively on a platform of deregulation and removing regulatory burdens, getting them out of the workplace, and really being a champion for small business and a champion for business, and getting the government out of your way. And so the expectation was, well, they're going to come in. I mean, as a regulatory defense lawyer, is, hey, they might just come in and abolish OSHA. That's the extreme view, and that hasn't happened. He has proposed abolishing a couple of other agencies like CSB, and maybe even combining the Department of Labor and Department of Education. They certainly have cut some regulations, using the Congressional Review Act, and they're proposing rules to wipe out others. And rescind and modify and cut down on the regulatory burden. But this was an area in particular that I was very interested to see, what would a Trump administration do? Are they going to continue to put out press releases at all? Are they going to get rid of this negative tone? Maybe this administration will wait until there's a final order. Maybe they'll correct things when they get it wrong. So what's happened over nearly the first 2 years of the Trump administration? Well, the first thing that happened was, if you look at the OSHA's press release page, their enforcement press release archive page on their website, you would see during the Obama administration 3 or 4 or 5 new press releases every day. And then all of a sudden, January 20th, 2017, the day that President Trump was sworn in, no more press releases. Just disappear. I mean, the old ones were still there, but there were no new ones. For more than a quarter, there was not a single new press release. And there was no announcement made about it. And we're all looking around and saying, well, it looks like what we thought was a possibility was that the Trump administration has abolished this ugly enforcement press release policy. No more of them. And we sort of, employers who were cited in that period, citations were still being issued. Significant enforcement actions were still being brought by OSHA, but no press releases. But then on April 29th, maybe it was April 28th, a Secretary of Labor was sworn in. Alex Acosta was sworn in. And so up until that point, There were really no political appointees over at OSHA or really over at the Department of Labor. So it was the administration tightly controlling what was happening at Labor. But then a Secretary of Labor was installed. And Secretary of Acosta is, really in the mold of a Bush administration type of political appointee. Fairly mainstream, fairly, I would say fairly moderate, certainly compared to other cabinet members in this administration. And he actually was a political appointee in a couple of different roles during the Bush administration. He came in, he heard from the career folks that what an important policy this is for OSHA, and he blessed it and said, go for it. Continue to run with it. However, I would like to see a change in, I don't know if his concern was the frequency, but certainly it was the threshold for what triggered an enforcement press release. So we saw 0 enforcement press releases during the first quarter of President Trump's administration, but after Secretary Acosta was sworn in, we saw a frequency return to pretty close to the same level we were seeing during the Bush administration. So it wasn't 4 or 5 of these a day, but it wasn't 0 either. We saw in the first full year during Secretary Acosta's tenure as a Secretary of Labor about 150 press releases. I'm sorry, I take that back. It was in the first year, I can't remember, it was about 100 and change. Since his swearing in to present, which is not quite 2 years, about 150 total press releases. So it's on average about 115 per year, which compares to the Bush administration about 150 a year. It's less frequent than we were seeing during the Bush administration, but close to it, but way, way, way less than we were seeing during the Obama administration. So we've got this, probably pretty obvious pattern. Republican administrations use the press releases, but they really reserve them for very significant enforcement actions. Democratic administrations, at least the last one, use them for almost, any enforcement action, fairly ubiquitous enforcement actions. Well, what about the tone and the quality of the press releases during the Trump administration? This has been something that sort of surprised me a little bit. Is that they reverted back to a frequency that looks more like a Republican administration, but they've retained the ugly tone of the Obama-era press releases. Still, 100% of the press releases issued during the Trump-Acosta era at OSHA have included an inflammatory and embarrassing quotation from a senior OSHA or DOL official, just like during the Obama administration. And here's an example, a pretty recent example, of a Trump-era OSHA enforcement press release. This employer failed to protect employees, resulting in a tragedy that could have been prevented if training was provided and machinery was appropriately guarded. So, it's not just saying there were violations. It was saying this employer caused a very, serious injury. I think in this instance, a death. This employer caused a death to one of his employees by failing to implement OSHA policies. The policies, from a timing standpoint, are still issued essentially right at the same time that the citations are issued. They still have the ugly quotations. They're just not happening quite as often. So it's a little mix, a little blend of the two administrations. What about the state OSHA programs? Aaron's going to talk a little bit about that.
Yeah, to answer the question, do state plans do this? The answer is yes, but barely. Based on our research and review of all the state plan websites, we only found 3 state plan states, agencies that have issued press releases, and when they do it, or to the extent that they do so, it's exceedingly rare and used quite sparingly. Interestingly, and those states are California, Alaska, and Washington. The Washington press release that we found was, unlike federal OSHA, not on the main web page, not readily accessible or findable. In fact, it took quite a bit of digging before we found the single example from Washington. Alaska, interestingly enough, we only found 1 or 2 press releases. The one we did find, though, does contain this sort of inflammatory language that Eric's been referencing, and the press release stated along the lines that jeopardizing worker safety with hazardous environments will be met with strong enforcement action. Quote attributed to the Labor Commissioner, that lives could have been lost, and the employers must be held to the safety and standards that our laws demand. At the same time that Alaska is issued this press release, though, they also do something that I think is more along the lines of what we're talking about, or what we would like to see, in a way that the press and the media could be used a little bit more effectively without the shaming. Alaska has on its website a section called Fatalgrams. Not sure if it's going to be quite as catch-on like Instagram has, but it's a log that, according to the website, provides public notice of workplace fatalities occurring under ACOSH, Alaska OSHA jurisdiction. And according to the agency, these are designed to assist employees and businesses with similar working conditions in an effort to learn from the accident and reduce injuries and fatalities in the workplace. These fatalgrams do not, however, identify the employer. They simply provide a summary of the incident, a description of how the employee died, and then provide some recommendations about how the employers and employees can hopefully avoid a similar scenario in the future. According to what I could find on the website, there have only been 13 fatalgrams issued since January of 2011, none since 2014. And so it's again issued sparingly and no real effort to shame. Not surprisingly, the California press release did contain some of the inflammatory remarks that we're talking about here as well. And like Alaska, I think Washington uses, and their website and their use of the media, I guess, is probably the most progressive or most interesting of all the agencies that I found. They have a section called Investigation Stories, which is a multimedia presentation actually narrated by inspectors describing the events that led to the significant injury or fatality. They talk about how it happened, how to prevent it. They also issue fatality bulletins. They have a section called Fatality Assessments and Control Evaluations, and near-miss alerts, which include root cause analyses and recommendations. In each of those tools, however, the employers, again, are not mentioned. They're just general descriptions of the type of industry and the type of incident that led to the accident or to the fatality. Just to summarize here, so that if you look at the numbers across all the state plan states out there, we only found the 3 that issue press releases. Indiana was the only state that the citations that are issued are available and searchable on the Indiana OSHA website, but there is no press release that accompanies them. There's no statements, no inflammatory statements, literally just the facts and just a link to the citation. All the other state plan states, we found no instance of these sorts of inflammatory remarks or public shaming. And then if you look, the one thing that's a little bit interesting, though, if you are in these other state plan states that do not issue press releases, it does not mean that you're out of the woods. Federal OSHA still is, on occasion, issuing press releases describing citations issued by the state plan states, and can have some of that same language. So it's somewhat of, I don't know what their decision-making or criteria are for when they adopt or issue these press releases, but I think along the lines of what Eric's discussed, if it is a high-value, high-dollar citation or contains some novel issues, we are seeing that they are still issuing the press releases regarding what's happened and been done by the state plan states. So I'll turn it back to Eric to talk about whether all this is legal or not.
Yeah, so I'll just talk about this very briefly, and only to invite some of you out there, if you ever suffer the fate of one of these nasty press releases, call me and let's talk about bringing a lawsuit that I've wanted to bring for over a decade now. My view is that the way the press releases are being operated now by OSHA, during the Obama administration and really continuing now into the Trump administration, because they have continued to embrace the ugly tone and the nasty quotations about the employers, is that I think there's a violation there of constitutional due process and the Administrative Procedure Act. And whenever I have this debate with Jordan Barab and others, they say, hey, look, the OSHA Act is very clear that we're allowed to, and in fact may be required to advance the purpose of the OSHA Act, to communicate with, the regulated community about enforcement efforts and enforcement actions. And that is absolutely true. And doing something like what Aaron was describing in, I think it's in Washington, where you educate people about enforcement, educate people about types of incidents that could occur, what hazards are related. You can do all that sort of education without shaming an employer. In fact, Washington is doing it without even naming the employer. And I think prior administrations were doing it even while naming the employer, just without shaming them. It's the shaming component of this that takes it a different direction. You're no longer educating. Your purpose for doing this is not educating. Your purpose for doing this is to layer on an additional level of punishment. And that is why I think we get into the area where this is unlawful. The Fifth Amendment of the United States Constitution guarantees the right to be heard before the government acts to levy a penalty against you as an individual or against a corporate individual. The Supreme Court has found in separate cases, not related to OSHA, but has found that executive agency press releases can be a form of penalty. And the context there is that if they are being used for the purpose of penalizing the employer, if negative media is the punishment and it is intended to be a punishment, that is a penalty that must be authorized by, must be authorized by your enabling statute, and B, can only be levied after you've had your day in court, after you've had due process. So my problem with OSHA's press release policy is twofold. First, from a due process standpoint, they're issuing these nasty press releases based purely on allegations before you've had your due process, and there's no question that they are intended to be punitive. And to the extent that there was any question about it, that question went away when David Michaels said in a speech and said in a bunch of speeches when he characterized this as regulation by shaming. His words, not mine. This is not about education. This is about regulating employers through a tool of negative press. Supreme Court said that's punishment, and you're being punished before you've had a chance to contest the citations, demonstrate that OSHA was wrong. So I think it's unconstitutional. I also think it violates the Administrative Procedure Act. The Administrative Procedure Act governs the manner in which federal agencies take official agency actions, including punishing those who are regulated by those executive agencies. And when a federal agency exceeds the scope of the APA, you can bring a legal action against the agency to stop that exceeding authority being exercised by the agency. And here, my view is why I think this violates the APA is because the OSHA Act defines what OSHA's authority is to punish employers. And that authority is to issue citations that they can characterize as other than serious, willful, and repeat. Their penalty authority includes the right to issue civil penalties, now in the range of $13,000 per violation for other than serious and serious violations, $130,000 per violation for willful and repeat violations. The OSHA Act also grants OSHA the authority to bring criminal prosecutions in certain circumstances with very defined, specific punitive penalties, a criminal fine and possible jail time. What the OSHA Act does not give OSHA the authority to do is to use negative media as a form of punishment. The only forms of punishment that OSHA is allowed to issue are citations with penalties and criminal charges, not negative media. And the Supreme Court has said negative media is a form of punishment. So if OSHA is doing this, and they're doing it for the purpose of additional layer of punishment for a violating or allegedly violating employer, they're issuing a penalty that goes beyond their authority under the OSHA Act, and doing so, therefore, would violate the Administrative Procedure Act. So I think there is a legal challenge out there for an employer who got one of these nasty press releases. I think whether you prove that the allegation was wrong or not, I think just the timing of the issuance gives you the right to challenge it, but especially a great case with a good fact pattern would be one of those where really nasty press release where OSHA is proven completely wrong. The employer suffers actual harm because of the press release, and that's pretty easy to demonstrate. I mean, we've got instances where employers have lost contracts, and the stated reason by the contracting entity was, we saw this nasty press release and we didn't want you to be involved in this project. We didn't want to draw negative attention to the project. We didn't want to invite OSHA scrutiny to the project, and you are in a bad place with OSHA based on this press release, so, no thanks, we don't want you around. We've seen circumstances where it was used to harm the employer on the consumer level. So nasty press release, OSHA proven completely wrong, harm the employer. I think there's a good lawsuit to be brought there. The problem with it, and the reason why I haven't been able to convince anybody to bring this lawsuit yet, is that because we are talking about suing the federal government, and it is arguably within the realm of within their official duties at the agency, it is, there's going to be immunity there, at least from a dollar standpoint. From my view, it would be next to impossible to recover money damages from the federal government, from OSHA, from the Department of Labor, the Secretary of Labor, in this lawsuit. What's likely, if we were to succeed, the success would be a declaratory judgment that either the policy in general is unlawful or unconstitutional, or that particular press release was unlawful or unconstitutional, and therefore maybe what you get is injunctive relief to take your press release down, injunctive relief to prohibit press releases generally, or at least press releases that have this particular shaming element to them. So I think there is an opportunity to fix what I think is a broken and unlawful policy, but it's going to be, probably pretty expensive without the opportunity to recover any monetary damages. Oh, and by the way, you're going to be poking the bear. So there's the fear of retaliation. Hey, why am I all of a sudden getting an IRS audit, a bunch more OSHA inspections, an EPA investigation, all 1 month after I sued the government about their press release policy? So I understand why no one's been willing to stick their neck out there, but hopefully one day we'll find someone who's willing to do it. So that was, a good chunk of the time about OSHA's enforcement press release policy. Let's move real quickly through some other forms of public shaming by OSHA. That was their main weapon to shame employers, but there's a few others as well. And the first one that I deal with the most often is OSHA's dreaded Severe Violator Enforcement Program. This was a program that was introduced during the Obama era with the purpose of directing enforcement resources at those employers whom OSHA believes demonstrate indifference to their OSHA Act obligations. And how does an employer demonstrate this indifference? They demonstrate indifference by being alleged to have committed violations that fall into one of these four categories. So it is essentially reserved for willful and repeat violators in bad circumstances, a willful or repeat related to a fatality, multiple willfuls or repeats related to process safety hazards or other high-emphasis hazards. And there's the list of high-emphasis hazards down there. And then any egregious enforcement action, which is sort of willful plus. So this program is out there reserved for what is supposed to be, truly bad actors. And it's not, and we've written a lot about this and spoken a lot about the Severe Violator Enforcement Program. I won't get into all the ways that it's broken. Today we're just going to talk about how OSHA uses shaming as part of this program. The one thing that they do, sort of take the second bullet first, is they are using their press release policy in the Severe Violator Enforcement Program. I'm pretty sure that every case that has resulted in qualifying an employer into the Severe Violator Program is a case that triggered an enforcement press release. And we've seen a bunch of them, and they are the worst of the worst. I mean, the most inflammatory language. They say the worst things about those employers, and they also say in the press release, this employer is now qualified into our Severe Violator Enforcement Program. So it identifies you as a bad actor, says really ugly things about you, the same way that we were talking about before. The other thing that OSHA does with the SVEP program that is all about shaming, all about and only about shaming, is that they host on their website an actual bad actors list. It's the Severe Violator log on OSHA's website, and it lists the employer, when they qualified in, what was the basis of the qualifying citations, how long they've been in the program, and it's something that you'll find on a Google search. You can find your way to OSHA's SVEP log of bad actors. So it's all out there with, for that list to be public, the only reason can be for public shaming, and there it is. And this has the consequence. Here's a list of the consequences of that, public shaming in the SVEP program. All of these elements really have the same risk, the same consequences for the enforcement press releases we talked about as well. Harm to the company's reputation, loss of customers, loss of contracting partners, defection of current employees leaving the company, say, man, this OSHA thinks my employer doesn't care at all about safety, I'm getting out of here, making it harder to recruit prospective employees. If somebody says, oh, I'm very interested in this job, they Google their prospective employer and read these ugly press releases, see that they're in the Severe Violator Program, hey, that's not somebody I want to affiliate with. It may have a serious impact on your ability to bank, get good credit. I do know an employer who very nearly lost their small business loan, and it was the lifeblood of the company based on a nasty press release from OSHA. I went in, I defended the company in their OSHA citations. I also defended the company before their bank and preserved their lifeline with the bank, but they almost lost it because of a nasty press release by OSHA. Insurance rates or insurance coverage certainly will be, has been, and can be impacted by negative press from OSHA. And then, negative press and the SVEP designation in particular are used very often, I would say always, when they exist in the context of either an organizing campaign by a union or at the bargaining table to get some leverage against the employer. So I think we're going to move on from SVEP to a couple of other tertiary ways that OSHA uses public shaming. I'm going to turn it over to Aaron, and I, in fact, am going to beg off this call right now because I'm on vacation, and I'm going to get back out to the beach with another frozen drink with an umbrella in it. But thanks, everybody, for joining us today, and you're in good hands the rest of the way with Aaron.
Thanks, Eric, and I think that's our dedication to our client base, that we're dialing in and presenting webinars even on vacation. So let me talk a little bit about the electronic record-keeping rule. I'm sure many of you, if not most of you, are following this rule. It's somewhat tortured history, including the fact that the final proposed / revised rule was recently released by the agency. You can read about that on our blog. We're in the process of going to be submitting comments regarding the proposed rule. A little bit of background about it. You don't necessarily, I think initially or conceptually, you don't think about record keeping as something that is likely going to be used to shame employers, but no big surprise that it's another tool in the agency's toolbox that they've been using to do just that. So this was the rule was originally published as the final rule in May of 2016 with two real requirements. The first, that establishments with 250 workers and that's in industries covered by the record-keeping regulation would be required to submit 300 logs, 301 incident reports, and the 300A annual summary. Additionally, establishments in high-hazard industries with as few as 20 up to 249 employees would be required to annually submit their 300A annual summary only. And how was that going to be done? In other words, how would OSHA collect and publish the data? It was going to be, and has been, for those of you that are covered by it, submitted electronically through a secure website. I'd be interested to hear how everyone has fared with that. We certainly have dealt with several clients that struggled and had some significant problems doing just that. The website wasn't working. They couldn't access the portal. They couldn't upload the data. And in one case, for an unfortunate employer, they ended up receiving a citation, and we're dealing with that now. But it's a struggle because the employer was not able, had not created a record of when they made the attempts to call. They didn't have any ID number from the helpline that they tried to call. So we're kind of trying to recreate that and piece of defense together. So that's issue number one, is can you get it into the portal? Can you submit it? And is it going to be secure? The assumption is, and OSHA has said, that they would scrub the employee identifying information from that are submitted by the employers. But I think, again, you have to ask the question, is that going to be effective? And in today's day and age, I think we're all aware of the headlines as far as hackers from whether it's someone someone on their bed in New Jersey, or to folks from Russia to China or across the world. There are folks that are expert and able to hack into this, and I've certainly seen instances of court filings in federal court where individuals attempted to redact the information but failed to do so, and suddenly private and personal information is made available. So that's another thing that OSHA is still trying to figure out and determine if they can indeed carry through on that promise. And I think what was also interesting, and this is where we start getting into the shaming angle of it, is OSHA's intent to publish data in, quote, a user-friendly database. So that meant that it would be searchable, sortable, filterable, exportable. In other words, that it could be downloaded and used. It can be distorted. I think we've all heard the different quotes about what data is or what statistics are. So if this information is going to be mined, that means it can be distorted. It's going to be used against employers, whether that's by union organizers, by their competitors, by plaintiffs' lawyers. And I think anyone who's had, whether it's a citation, whether it's a lawsuit, when it's depicted and discussed in the media, allegations are often taken as facts, just like Eric talked about with the press releases. It's an assumption that whatever is put in writing and published is true, without really getting into the defenses or what actually happened in the final outcome. Another quote from former Assistant Secretary Michaels, here he's referring not to the regulation by public shaming, but by the E-Recordkeeping rules, that our new rule will nudge employers to prevent work injuries, to show investors, job seekers, customers, and the public that they operate safe and well-managed facilities. Access to injury data will also help OSHA better target compliance assistance and enforcement resources. So what's interesting, and I think we certainly found this quote to be quite telling, is that normally and usually negative outcomes may be an unintended consequence of a policy or a rule or a requirement. Here, I think these are all things that the agency fully expected, whether intended or expected to happen. And I know Eric's already talked about a number of these issues, but just like the press releases, just like the citations, the expectation is if an employer has a high rate of injury, or at least that's what the data allegedly shows, is that is going to be used to discourage customers from doing business with them. It could, again, impact their ability to secure contracts with their customers. Like I talked about earlier, it could go, your competitors could use it against you. You could find it on your Wikipedia page. It will scare off prospective employees, may scare off your current employees as well. You can, again, lose access to loans, and also impact your ability to secure insurance coverage, as well as the rates that you're paying. So that's the rule that was issued, came out towards the end of the Obama administration. So we'll talk about a little bit now about where we stand under the current administration. So whereas Obama's OSHA intended for this data to be collected, it was going to be published immediately, which meant that you submit it at the end of the year as soon as the agency can process, collate it, and put it into that format that was capable of being searched and downloaded and all those fun things. The Trump administration is delaying publication of this data now for 3 years. And the reason that they have given for doing that is that they're using this data to determine and set enforcement priorities, They might be using it in the course of or as part of an investigation, and so they don't want to tip their enforcement hand, by publishing the data. So while there is some relief, it bears repeating that relief, and I think this is kind of consistent with what we've seen from OSHA in the current administration, is that they've pulled back some, but not entirely. In other words, so this data, the e-record-keeping data that's submitted, is still going to be released and published at some point. It's just further down the road. It's not now. It's in 3 years. So let me just back up. Sorry. So the one issue that kind of remains in the balance, and it's not entirely certain that the data that is gathered will not be released sooner, is that the public citizen has filed a lawsuit challenging, and this is a non-profit public interest organization, filed a complaint against OSHA after it submitted 3 FOIA requests, now 4, for work-related injury and illness data submitted under the rule. It amended its complaint in April of 2018 after making this 4th FOIA request for the same kind of information. In response, OSHA denied public citizens' requests in full under 7E FOIA exemption, reasoning that, as stated in the preamble, to improve tracking of workplace injuries and illness, final rule, OSHA plans to use establishment data for enforcement targeting purposes. Disclosure of the data before and while it is being used to select establishments for inspection would in turn disclose OSHA's techniques and procedures for law enforcement investigations. That's the tip the hand explanation that I referred to before. So as such, OSHA had claimed that the data is exempt from disclosure while being used for these targeting purposes. This case is currently under review, with the most recent filing being a reply memorandum in opposition to public citizens' motion for summary judgment that was filed by OSHA. The reply memorandum was filed by OSHA just last Friday, August 17th. Now, the last, and this is not quite a press release, but another tool that had been used by OSHA. Whether we can debate, folks may debate, and I'm sure the agency, as Eric referred to, Jordan Barab would take issue with this. The fatality info that had been on the agency's website being used to shame and draw attention to employers as well. If you recall seeing this back during the Obama administration, there was in essence a scroll that ran across the front page. So when you logged into www.osha.gov, there was a scroll that listed all of the workplace fatalities that had been reported to the agency. And the issue there was that these fatalities were not necessarily, that there was no citation that had been issued, it may not have even been the sort of a fatality that it could have been someone dying of a heart attack, it could have been something that was entirely unrelated, obviously, to the employer's workplace safety and health program or anything along those lines. That scroll disappeared from the website as of August 25th, 2017. And OSHA explained that previous listings, in doing so and removing it from the website, the previous listings including fatal incidents that were outside of federal OSHA jurisdiction, that may not have been work-related, or where the employer was not cited for a violation, had been removed. And so I think employers, certainly employers that breathed a sigh of relief, because the last thing, again, you want is to draw attention to a fatality that occurred at your facility that was not work-related, or where you were not issued a citation, again, because I think there's this assumption that, well, someone died at this employer's facility, they must have done something wrong. It's somewhat to our surprise, I think, again, that may be coming back. Whether the scroll is going to come back, I'm not entirely sure, but there is still fatality information available on the website, just not on the home page. Trump's OSHA announced that public fatality information would only be detailing the incident, and this, I think, kind of tracks what we saw more during the prior administrations, the Bush administration, and before that, that you just get the facts again as to what happened, where they're going to have the employer's name, but that would be it. Interestingly, just this past June, on June 28th, the Senate Appropriations Committee, as part of the budget process, instructed OSHA to resume what they refer to as the timely web postings of on-the-job deaths, regardless of whether OSHA issued a citation. So whether or not how this is going to affect or impact the scroll remains to be seen, whether that goes back. But right now, it does require a few clicks through the website, but it is quite easy to find. And so that page on OSHA's website does include fatalities, both where a citation has been issued as well as where no citation has been issued. So that hopefully gives everybody a sense of where things stand. I think to just kind of summarize again, we've seen the agency definitely take a few steps back from the sort of rhetoric, perhaps I guess not so much step backs from the rhetoric, certainly step back from the frequency. The rhetoric may have softened a tad, but I think by and large it still is inflammatory when it's used. So this SVEP program is still in place, and the E-Recordkeeping rule is going forward. So there are certainly a number of ways that employers are going to encounter the sort of public shaming that we've been describing, regardless of whether or not they're ultimately found to have committed or to violated the regulations. So we hope you all found this to be of value. There are still 4 more webinars remaining this year. Our next one will be September 18th. We're going to be talking about the exciting world of walking working surfaces, talking about the new-ish standard that OSHA is enforcing. In October, we'll be covering repeat and willful citations, and you can see here on the calendar the other webinars that we'll be doing for the rest of the year. Also encourage you to check out our blog, OSHADefenseReport.com. As I think referenced before, we recently posted something about the new E-Recordkeeping rule. There's also some information about the recent district court decision out of the D.C. Circuit regarding EPA's RMP rule. I encourage, if you are subject to the process safety standard, to check out on our website more information about the summit that we'll be hosting in Washington, D.C. on October 23rd, 2018. Should be a full day program with a lot of speakers from the government, the stakeholders, and last but not least, Eric referenced this before, and I'll just make another plug for our event here in Chicago on September 25th in the afternoon at the Union League Club, where we're going to have speakers from OSHA, from the National Labor Relations Board, from the EEOC, and a number of our clients as well that are going to be talking about all the different issues of the day. So I do not see any questions regarding today's program. So with that, I will thank everybody and hope to be with you all again on a future webinar. Thank you.